Good morning, everyone. I'm Dominique Morris. This is the early morning edition, The Law's Accountability, exposing the hallway bureaucracy of what I experienced yesterday was crazy. But I'm here to fill y'all in on how our US Marshals treat people. The weight of the badge. Good morning, everyone. When a citizen stands before law enforcement, they're standing before the concentrated power of the state. See, when the law enforcement agencies is federal, okay? When it wears the badge of the United States Marshals Services, that power is immense. It is a power backed by the full weight of the federal government, funded by the taxpayers, and strictly bound by the Constitution of the United States. And with that comes immense power. Power comes a mandatory, non-negotiable requirement. Absolute accountability. See, the badge is not a shield against accountability. It is a bond of public trust. But on May 18th, 2026, when I walked into the local office of the US Marshals Service to address a catastrophic operational failure that took place under their authority in Ellis County, that bond was shattered. I did not go there to cause a scene. I went there just as a certified advocate. I went there to present facts of severe injustice. The fact that personnel operating under federal authority swept into Dallas, Grand Prairie, and Ellis County bypassed standard identity verification protocols and wrongfully seized the wrong human being. See, that era alone is a constitutional crisis. But the response I received was a masterclass in official disrespect and administrative lawlessness. I was flabbergasted. I even reiterated to the guy, I said, "Are you sure this is what you want to do?" Here's the factual breakdown of all this. The hallway expedient. Let us look closely at the facts of how this injustice was handled. When you bring matters of this magnitude, a matter involving unlawful detention, civil rights violations, and potential federal liability, to a law enforcement agency, procedural integrity, understand this, procedural integrity dictates a specific response. It requires a private setting. It requires an intake officer. It requires a formal logging of a grievance. It requires dignity of a closed door, because the violation of a citizen's liberty is a grave and serious matter. Instead, two U.S. Marshals looked at this crisis and decided it was an inconvenience. They refused to bring the matter into an office. They refused to sit down at a desk. Instead, they chose to hold an open, public meeting concerning a federal civil rights issue out in a public hallway, right in front of the elevators. Think about that visual for a moment. As the elevators dinged, as personnel walked by, as doors opened and closed, as the security guard for the clearance on the 16th floor stood there in his white shirt, these two federal officers stood in a public corridor trying to play a game of jurisdictional hot potato. Hadn't played that game in a long time, but they brought me up to speed. They shrugged their shoulders, claimed they lacked jurisdiction to act on an incident that occurred under their own operational umbrella. In Dallas, in Grand Prairie, it started in North Dallas, led all the way to Ellis County, and told me to go to the FBI. They did not want a paper trail. They did not want a formal record. They wanted to use the public nature of a hallway meeting to minimize the severity of the failure. See, to make me feel exposed. They wanted to make me feel belittled and to make the issue feel small. But their disrespect did not hide their failure. It actually only highlighted it. And today we're going to look past their dismissive attitude, and we're going to look directly at the law of this. Because while those marshals wanted to act as if no rules applied to them in the hallway, the statutes tell a very, very, very different story. See, the federal statutes violated. Let us lay out the law, since they didn't. When those officers refused to handle this matter professionally and tried to pass the buck, they didn't just act rudely. They bumped up against federal and state statutes designed to prevent exactly this type of official evasion. First, let's address the underlying arrest. The Fourth Amendment to the United States Constitution guarantees the right of the people to be secure in their persons against unreasonable search and seizures. When law enforcement executes a warrant on the wrong person because they failed to perform basic duties, basic standard identification verification, that is a Fourth Amendment violation. It is an illegal deprivation of liberty without due process of law. Second, let's look at their conduct. Under Title 18, United States Code, Section 242, deprivation of rights under color of law. This statute makes it a federal crime for anyone acting under the authority of the government to willfully deprive a person of a right protected by the Constitution. When federal task force wrongfully detain an individual and the supervising agency actively evades an administrative review of that detention, they are operating under the color of law to perpetuate an injustice. Third, by holding a public hallway meeting to dismiss the valid civil rights complaint. These officers ran afoul of DOJ standards of conduct and administrative integrity. Internal Department of Justice policies explicitly dictate how citizens' complaints must be processed. They require formal intake, documentation, and referral to the Office of Professional Responsibility, or the Inspector General. Shunting a complaint to the elevators and telling them to go to the FBI without logging the interaction is a direct violation of administrative protocol and a breach of operational integrity. See, the state law context, the official oppression of all of this is horrible. And furthermore, because this operational failure occurred on Dallas, on Grand Prairie, and blanketed and waved all the way to Ellis County, we must look at the cross-jurisdictional liability. Federal Fugitive Task Force rely heavily on local county deputies working under the federal Title 21 or Title 18 authority. This means local hands were involved in this federal failure. Under the Texas Penal Code Section 3901, official oppression, a public servant acting under color of his officer or employment commits an offense if he intentionally subjects another to unlawful arrest, detention, or seizure. When local affiliates and federal task force members fail to verify and identify, book the wrong person into a facility, and then the federal overseers refuse to audit the logs, they create a chain of custody built on unlawful restraint. The marshals tried to claim they lacked jurisdiction in Dallas, in Grand Prairie, in Ellis County to avoid dealing with the fallout, but you cannot deploy a task force into a county, Dallas, Grand Prairie, Ellis County, to take a citizen's freedom away and then suddenly claim you lack jurisdiction. You claim you lack jurisdiction to investigate why you took the wrong person? You cannot have both. You can't have it both ways. You cannot hold the power to break the law, but claim you lack the power to fix it. It's baffling. It's mind-blowing, and it's downright daunting. But the strategic response here is the light. So how do we respond to the hallway bureaucracy? How do we respond when the system plays hot potato with our Constitution? Not just the Constitution, but with our constitutional rights. We do exactly what they told us to do, but we do it with full force, the full force of the formal law. They told me to go to the FBI. Okay, so we're going to the FBI. But we're not going to the FBI with a whisper. We're filing a formal written civil rights and color of law complaint with the FBI Dallas field office. We are putting the names of the agencies, the dates, the operational failures of these agencies, and again, the names of the officers into a permanent federal investigation recorded. And we're going over their heads. We are bypassing the local elevator banks. And we're taking this straight to the Department of Justice Office of the Inspector General, the OIG, in Washington, D.C. We are demanding a complete independent administrative audit of the North Texas Fugitive Task Force deployment. We're needing their logs, their warrant execution protocols, and their identity verification standards in Dallas, in Grand Prairie, and in Ellis County. We're also demanding that the OIG investigate the administrative misconduct of utilizing public hallways to evade formal intake procedures for civil rights, complaints, and the public. We are not going to lay down. But in conclusion of all of this, the US Marshals who stood by those elevators thought, by treating this matter with disrespect, they thought they could make it disappear. They thought that by bypassing the buck to another agency, they could exhaust or resolve. But listen, they miscalculated. They forgot the law belongs to the people, not to bureaucracy. They forgot that transparency is the ultimate check on official arrogance. See, we will not allow the serious business of human liberty to be treated like a hallway sideshow. We will not allow federal officers to hide behind administrative double talk while citizens are wrongfully stripped of their rights. We have the facts, we know the law, and we will use every legal avenue available, from the FBI to the departments of the DOJ to the departments of the Inspector General, to ensure this injustice is documented, reviewed, and corrected. Justice is not a game of hot potato. It is a constitutional mandate, and we demand it. We demand that it's delivered. Thank you. I'm Dominique Morris, and this is a morning edition of the OR.